Right, we go back to our top story. Has been dominating the news. President Cyril Ramaphosa's legal team will approach the Constitutional Court tomorrow to review the damning Phala Phala report. An independent panel this week found that the president may have a case to answer to in relation to the theft of hard foreign currency from his Limpopo farm back in 2020. For more on this, we're joined by legal expert Modidima Mannya. Good to have you. Good evening, and thank you very much for your time.
Good evening.
Let's start a little bit slowly here and look at some of the comments that this particular panel has made. One, they say that it's not the function of this panel, firstly, to inquire on whether the president is guilty or not of a series of violations of the Constitution or serious misconduct. So they are saying we are not finding any guilt on the president, but we take this particular term, whether sufficient evidence exists, to mean that based on the information provided, can we come to a conclusion that the president has got a case to answer to? How do you challenge that, particularly in a constitutional court?
Yes, maybe before we go there, let's deal with the difficulties, the serious difficulties that Parliament is going to face, the National Assembly, based on that report. Number one, and if you go to the conclusion makes findings, and it says he may have done this, he may have done this, he may have done this. Those are findings in the final analysis. That's what Parliament has to deal with. But let's look at the first issue of Section 34(1) of the Prevention and Combating of Corrupt Activities Act. Section 34(1) creates an offense. Now, who can determine whether somebody committed an offense? It's only a criminal court. As a matter of fact, there's no other body who can determine whether a person committed a criminal offense. So in Section 34(1), you find an offense, and only the criminal court can deal with it. The second issue Parliament is going to face a difficulty that it has created. Parliament passed the Members' Ethics Act, and in terms of the Act, there's supposed to be a code of ethics for members of the executive. One of the issues which is the subject of this thing is the allegation of paid work by the president, which is one of the conduct issues in the code of ethics. Now, Parliament assigned the responsibility to investigate such contraventions to the public protector by an act of Parliament, called a law of general application. Now, they can't, through the rules, amend that law and take back the power. So I'm raising these two issues, for instance, to demonstrate to you that, put the president aside. The National Assembly has got a duty to act lawfully, so it still on its own has to apply its mind whether in dealing with the issues that are before it, it has the authority to deal with those issues. Yeah. If the National Assembly is going to determine whether somebody has committed an offense, it's encroaching on the separation of power. It's constitutional matter, serious constitutional matter. So if it is taken...
Let me just come in there. I mean, that's precisely it. And I'm asking, therefore, is the president not premature in his decision to want to challenge this in court, even before the National Assembly has determined whether they are accepting this report and will be acting on it or not?
Not really. I mean, in my view, he's got two options. He can go to court now and challenge this report, or he can wait for the National Assembly to act, in which case he will probably gain more ground of review, depending on how far it goes. But remember, one of the things, and that's why I wanted to focus on the difficulties that the National Assembly is facing. In terms of the rules on impeachment, there are two categories. There's what they call serious misconduct, or serious, where there's serious violation of the Constitution or misconduct, and there's what they call less serious. Now, for a serious misconduct, it's also a requirement that the president must have acted in bad faith. So even if the facts are established that he may have done this or not done this, you still have to establish bad faith on his part. And if it does not appear explicitly from the report, Parliament is not going to write it into the report. And I think we must correct the perception that when the rule says Parliament, the National Assembly is not bound, it means the National Assembly can just ignore. This process of the panel is the first phase, and it's part of the legal process for impeachment. And I don't know how the National Assembly will move to the next phase unless it clears this hurdle.
Yeah, there are parties who are saying the National Assembly would be breaking the law, in fact, if they ignore the recommendations of this panel based on, of course, the previous court judgments that said Parliament failed in its oversight duties previously when, for example, it had to deal with the Nkandla matter.
Look, the National Assembly cannot ignore the recommendations. It is required to consider them and apply its mind. And it is in that context that I raise these major issues that they are going to be confronted with. Of course, if the National Assembly were to say, well, we adopt the report as is, so we accept that there's a contravention of Section 34.1, and that we can do an investigation into paid work, then it will still be acting unlawfully. If it just takes the report and say, look, there's a public outcry about this report, let's throw it to the dustbin, they will be breaking the law. So they must consider it. And that is not the issue. The issue is, in their consideration, they now have to do the sifting themselves because the panel was meant to do the sifting for them. So they have to take into account all these issues. They can't ignore them.
How do you then challenge this view that even SATU is expressing, and I've seen a number of reviews of this report coming forth saying the report relied on aspects of evidence that were hearsay?
Look, Thabo, the law is very clear about hearsay evidence, and it doesn't matter whether it's in a disciplinary hearing, it's in a court, or anywhere else. Where there is an adjudicated process, hearsay evidence is inadmissible unless the people that you are saying have told you the story come and confirm what you are saying. But beyond that, the evidence generally has to be tested. I mean, even if you go to court with a document, the authenticity of the document can be disputed. And if the authenticity of a document is disputed, whoever brings the document must prove it. Now, it gets worse with, relying on unsigned statements, relying on newspaper articles, relying on hearsay, which can be tested. The panel could not test that information because it was not permitted in terms of the rules to hear oral evidence. The only way to validate this evidence is through testing it through a confrontation process, which is examination and cross-examination.
So why would two judicial officers, some at the highest rank, I mean even at the rank of the Constitutional Court, say something like this, paragraph 86, although Mr. Fraser has not disclosed the source of his information, given the seriousness of the allegations and the impact that it will have if proven untrue, we assume that at an appropriate forum and when the need arises, he will, when called upon to do so, disclose the source or sources of his information.
You know, the law that I know that we got from the judges is that hearsay evidence is admissible in urgent proceedings on condition you disclose the source of your information. I've never seen a judgment that says you can rely on hearsay evidence and then say to and make a decision and then say to the person, in future when there's further processes, you will then tell them who's your source. The adjudicator has to make a value judgment on that evidence. I'm not sure how they arrive at that conclusion. And I think it's one of the major fault lines in the report and the process.
Take a break. We continue with Modidima Mannya, legal expert, with us tonight, as the President, through his legal team, has indicated, indeed, that he'll be filing papers to review this report. Stay with us. Back with you tonight on In Focus, still with us, legal expert Modidima Mannya. Of course, we are looking at what are the legal challenges that this particular panel report present to the National Assembly, to the President, and of course you're hearing there from Sakchi saying this could possibly plunge us into a constitutional crisis. There's some rather interesting comments that are coming out from this report from the judicial officers. I mean, some of the other things, for example, that they are pointing to is some aspects of the evidence that has been proffered by President Cyril Ramaphosa, in particular pertaining to the source of the foreign currency, is also hearsay. For example, the President pointing to Mr. Ndlovu, who is alleged to have received the foreign currency, and they are saying what the President is saying concerning the source of the foreign currency is based on what he was told by Mr. Ndlovu. Why are they highlighting that?
Look, I mean, that's a very interesting part of the report, because I think I've seen somewhere where they say he doesn't have personal knowledge. Now, if he doesn't have personal knowledge, whatever he told them should not be admissible. But it goes further than that. If he doesn't have knowledge of how the money got there, why would he have committed some offense? Because he doesn't know how the money got there. That's what the panel is saying. Now, he doesn't even know what happened to the money. I mean, for instance, there's a story, and I think this is the difficulty, Thabo, in my view, with this whole process. You know, there are police investigations, there's public protector, there's South African Reserve Bank and all this. I think the danger of our impatience has led us here. Understandably, we are frustrated by the slow pace of investigation in many cases. But I think we are not in a constitutional democracy, be in a state where the end justifies the means. Here, the rule of law is primary. You may have all the facts right, but if you don't comply with the law, you are in trouble. And I think those are the contradictions that you find in the report, which makes it difficult to understand what exactly is the position.
How much weight, for example, how much of this report probably would stand on information that is what is called common cause or undisputed facts, that, yes, there was foreign currency present and the so-called foreign currency, even on the President's version, was concealed or stored inside a sofa? How much of that how much weight would that hold in them reaching the conclusion that they have reached around the conduct of the President?
But is the charge against the President the existence of foreign currency or not? Or is it because he failed to report the theft of the foreign currency, or is the charge that the money was not declared? You see, that's the difficulty. And I think, you know, this is what Dr. Posa calls air. You know, when you make allegations against a person, they must be specific. We must know, I must know, what am I accused of? I must know what I'm supposed to respond to. And I think, again, it goes back to, I can repeat that 50 times, the process, this process of the panel was never going to deliver on a complex matter like this. For instance, as you can see, the police, we may fault them, but I'm sure they understand that they need to go and collect every piece of evidence and join the dots, formulate a position, present it to the National Prosecuting Authority for a determination of whether there's an offense and what offense it is. So we can argue as much as we want. The reality is the report is telling us. Yeah. In fact, at one part of the report, they say there are so many unanswered questions, we don't have the tools. Yeah. They say you need to excavate. I mean, excavation is quite a strong word. I think for me, it emphasizes that there's a need for a more intense investigation. Now, how somebody reached a conclusion when they concluded themselves that we don't have all the information.
But are they contradicting? You're correct, but are they contradicting themselves? For example, as you put it, that's what they say. They also say that the truth of what really happened lies beneath the unanswered questions that are foreshadowed by what we are being told from the information that's placed before us. But then they also continue to say, but still we are able to make our findings and provide our reasons and make our recommendations based on this information that has been given to us.
Yes, it's a very difficult proposition to understand, in all fairness. And I think we must not be understood to be not appreciating the difficulties which the panel confronted. But I'm also saying, in my view, confronted with that type of situation, the panel should have just stated the information that it obtained and decided not to express an opinion. It was not actually obliged to tell the National Assembly whether the president may have committed this or that offense. If the circumstances are such that they cannot, they were in a situation of impossibility, and they should have limited their report to just recording and documenting what they have established through the information.
Does this then teach us something? I mean, are we learning, for example, that this panel process should not be rushed? For example, in this instance, maybe the panel would have, as they say, they know that the Hawks are investigating, they know that the Reserve Bank is investigating, but they don't have that information. They don't have access to that information on record. Should we have waited for that information to be made available to this panel, and maybe they would have reached a much more conclusive decision as far as what the Section 89 committee should do?
You know, I listened to the chairperson of the commission saying, you remember, he said he's taking the extraordinary step of addressing the question of somebody who said, if you don't bring the Hawks here and whoever, this is not going to be credible. And he was so emphatic to say, listen, that was not our job. Now, one of the things that is a bit mind-boggling for me is when the panel says we were only going to consider what was placed before us by the members of parliament, and then go on to decry the fact that there's a Hawks investigation, we don't know what is happening, what is the outcome. The Hawks, the police spoke to a portfolio committee, the Reserve Bank spoke to a portfolio committee. We don't have that information. Now the question is, if you had that information relative to what the chairperson of the panel said, that they were only confined to that, who was to place that information before them? And if it was placed before them, what would it have, what would it have meant? But I think the other side of it is that, in all fairness, the process would have required all this information to be made available for an informed decision. I mean, as I say to you, I'm curious to understand. Let's say, for argument's sake, the panel were to say, no, there's no evidence of wrongdoing on part of the president, and 6 weeks later, the Hawks arrest the president for the same thing that the panel said there was no evidence. What would it mean? And the lesson to learn here is that in a constitutional democracy, the rule of law is supreme, and we must learn to be patient, irritated as we may be, because we have now delivered this quagmire that almost created a chaos. Instead of us dealing with the issue of the accountability of the president, we are now stuck because we need to clear these bushes around this fraud report, these fraud procedures, this confusion about who has information on what. So the very objective for which this process was initiated has in fact been defeated.
Is that as a result maybe of the cross-section between the political process, political parties wanting to remove their opponent in politics and using legal instruments to do that?
Well, I suppose. I mean, as I say, I thought when people marched on the office of the public protector, and I thought it was very unfortunate because it sought to create the impression that the public protector was not doing her work. And I commend her for putting her foot down. She's a professional. She's a very important functionary. She must do her job without fear or favor. And I think that the fact that sometimes these organs of state are put under pressure is creating this problem that we have. So this problem, in all fairness, is created from the side of the National Assembly. And the National Assembly, in my view, should take full responsibility for this current situation.
Let's talk about that now. If the president challenges this particular report, does that scupper the work of the National Assembly? Will they be able to sit and vote on this particular report? I'm asking this because we saw in the other process, for example, of the removal of the Chapter 9, a lead of a Chapter 9 institution, the Advocate Modidima Mannya. She tried, for example, to stop the work of the Section 194 panel and went to court. And the panel went ahead anyway.
Yes, it is because unless there is a court order which stops the process, there's nothing that prevents the Parliament, the National Assembly to continue. But there's also a courtesy that should exist between organs of state. And the National Assembly would probably have to apply its mind to determine whether it also may need the guidance of the Constitutional Court in the light of the situation that it finds itself. But it may also decide that it wants to proceed with the process. But you must bear in mind that the best that can be done on the 6th is to adopt the report if they so agree, and probably work on appointing an investigating committee. Now, there's a long way to go because there's still step 2, which is the investigation itself. We don't even know how long it will take. And there's step 3, which is the actual impeachment, which is the motion which must be voted for in the National Assembly.
Appreciate your time. Thanks so much for coming on. Legal expert there, Modidima Mannya, joining us tonight on In Focus. We continue in a moment with your leading stories on In Focus. Stay with us.